Okay, let's get the official bit done. Good morning, good afternoon, good evening, and welcome to Global Lawyers of Canada's Virtual Mentor office hours for an extra special, very early morning session here on the West Coast. And today we are joined by Jade Buchanan and Kelsey Franks from the Vancouver office of McCarthy Tetrault. And today they're going to be sharing a little bit about privacy and technology law in Canada. And if you're not following Jade and Kelsey on LinkedIn yet, make sure you do, because they do post lots and lots of articles that they've been writing all about privacy and technology law. So you can learn a lot just by following them on there. But I'm going to give you a little introduction to both of them, and then I'm going to hand it over very swiftly to them to kick off the session. But before we do that, we're going to do a little bit of housekeeping for everybody. We do encourage you to turn your cameras on. It does make it a lot easier for our speakers to actually talk to human being faces rather than just tiny little squares with your lovely names written on them. But you know, if that's not convenient for you, don't feel pressure to turn it on. But we do ask that you all mute yourselves right now. That way it gives everybody a chance to actually hear our speakers, but there will be an opportunity later on in this session for you to ask your questions live to Jade and Kelsey. So if you do have a question, please do drop it in the comment box and we'll get through as many of those as we can today. But let's kick it off. So Jade is currently an associate, but he is going to be a partner effective January 1st. So yay, congratulations, Jade. Jade and I did used to work together at McCarthy Tetrault. So that's a little link there today. And I've realized that Kelsey and I were probably in the building at the same time as well, but probably didn't come into contact with each other back then. But Jade's official bio, now this is literally cut and pasted from the McCarthy Tetrault website, so I apologize, but if it's not up to date, it's McCarthy Tetrault's fault. Jade is an emerging leader in privacy and data protection law. He's worked on some of the largest cybersecurity incidents in Canadian history and dozens of other incidents, including data breaches, ransomware attacks. He also has extensive experience with complex data sharing agreements, regulatory compliance, and responding to inquiries from privacy commissioners. Beyond experience with Canada and British Columbia's private sector privacy legislation, PIPEDA or PIPEDA, CASL and PIPA, Jade has extensive experience advising on British Columbia's public sector legislation, the Freedom of Information and Protection of Privacy Act, for public bodies and their service providers. Jade is also a certified information privacy professional in Canada. Jade's technology transformation experience includes drafting and negotiating a range of IT outsourcing, licensing, maintenance, and support agreements. He has particular experience negotiating large cloud-based outsourcings and the acquisition of cybersecurity software and services. He is also a relatively new dad and a dog parent. Kelsey Franks is an associate in the business law group in Vancouver. She maintains a general corporate and commercial practice, including mergers and acquisitions, corporate governance, corporate finance, and project finance. Kelsey represents clients in a range of industries, including financial services, infrastructure, and technology. Kelsey obtained her BA Honours in Political Science and International Relations from the University of British Columbia in 2014 and her BCL LLB from McGill in 2018. She also articled with McCarthy Tetrault, and she's now Jade's junior. So welcome. Thank you so much both for joining us today, hopefully answering all of our questions. And I'm going to hand it over to the two of you.
Hi, everyone. Thanks for joining us today. As Siobhan mentioned, my name is Kelsey Franks. I'm a second-year associate in the Vancouver office of McCarthy Tetrault. Today, Jade and I are going to be discussing privacy law in Canada. I'm going to start with kind of a high-level overview of the privacy law landscape, and then I will be handing it over to Jade, who's going to be delving a little bit more deeply into some of the hot topics in privacy law. So the idea that an individual has a right to privacy is not particularly new or unique to Canada. The most well-known formulation of the right to privacy actually appeared in the late 1800s from two American jurists, and it was defined as the right to be let alone. Now, it wasn't actually until after the Second World War that the right to privacy started to appear in legal instruments. So we're thinking of things like the Universal Declaration of Human Rights, the European Convention on Human Rights. And in some ways, this can actually be seen as a reaction to the lack of privacy that existed under a lot of the authoritarian regimes that appeared in that period of time. And the belief that perhaps one way to avoid the emergence or the excesses of those kind of authoritarian regimes would be to enshrine the right to privacy in both international and national law. Now, it was in response to the recognition of the right to privacy at kind of an international level that Canada introduced the Federal Privacy Act in 1982. And if you think about timing, this was about the same time as the Charter of Rights and Freedoms, which enshrined other kind of human rights in 1982 as well. Now, the Privacy Act, which is still in force today, doesn't provide individuals with kind of a blanket or an absolute right to privacy, like some of the international instruments did. But instead, it recognizes the need to balance an individual's right to privacy, but also with the government's need for information about citizens in order to kind of govern properly. Now, the Privacy Act does this notably by granting individuals the ability to kind of control who collects their personal information, as well as how that information is used and when that information is disclosed. So one important thing to think about is what constitutes personal information. It's defined relatively broadly as any kind of information that can identify an individual. So it can range from everything from a name, an address, an email address, to personal like financial information, personal health information, etc. So it's fairly broad. Now, in terms of the Privacy Act itself, it's fairly limited in scope. So at the time, the federal government enacted it, it applies only to the collection, use, and disclosure of personal information by federal public bodies. And what this means is that due to Canada's kind of federal structure, that each of the provinces and territories have had to enact their own legislation that is applicable to provincial or territorial public bodies. Now, even with all this kind of legislation applicable to public bodies, both at a provincial as well as the federal level, there was still a really big gap in the late 80s and early 90s regarding the application of privacy law to private organizations. So we're talking about things like charities, trusts, corporations, most importantly. And it was actually Quebec in 1993 that enacted the first Canadian privacy legislation that applied to private sector organizations. And this was the Act respecting the protection of personal information in the private sector. And in 1993, we're thinking like this is way before widespread use of computers. The internet was still in its nascency. And so the Quebec Act really focused on privacy in a physical as opposed to a digital world. There was kind of a period of time in between 1993 and the early 2000s where none of the other provinces enacted legislation. But then in 2002, the federal government enacted the Personal Information Protection and Electronic Documents Act, which is the full name of PIPEDA or PIPEDA, or any variation of how you want to pronounce that term. And again, this was at a time where there had been an increase in the use of the internet, computers were more widespread, and so PIPEDA was very different than the Quebec Act in the sense that it recognized issues like cybersecurity, data breaches. It recognized that we live in a very digital as opposed to a physical world often. Now, because of these changes as well, PIPEDA took a very different form of legislation than the Quebec Act. So the Quebec Act was very prescriptive in nature. It set out clear rights and obligations of private sector organizations in respect to their handling of personal information, while PIPEDA actually adopted a kind of more principled approach. So essentially, PIPEDA sets out a series of principles that are designed to guide or inform private sector organizations' handling of personal information. It's less prescriptive in nature. Notably, PIPEDA is similar to the Privacy Act in that its scope is relatively limited. It essentially applies only to federally regulated private sector organizations. So we're thinking about things like banks and airlines. It also applies to private sector organizations that operate or handle or transfer personal information across borders. So this could be interprovincially or nationally. So, where an organization transfers personal information to, say, the United States. The other place that PIPEDA applies is to private sector organizations that operate in provinces or in jurisdictions that do not have substantially similar legislation protecting personal information. Now, there's only 3 provinces that have been deemed to have this substantially similar legislation. One of those is Quebec, with the Quebec Act that was enacted in 1993. The other 2 are BC and Alberta. Now, BC and Alberta actually drafted their privacy legislation applicable to private sector organizations around the same time. They did it together. And while there are some notable differences, most significantly around breach notification, which I think Jade might discuss a little bit later, there are very similar in nature, and they are kind of seen as a response to what many perceived as some of the shortcomings of PIPEDA. They are, once again, very prescriptive in nature. They provide organizations with a lot more clarity around their rights and obligations. And yeah, I would say like they're very, very structured differently. Basically, I'm not going to get into the kind of exact technicalities and the differences between all these different types of legislation, but I wanted to mention them and discuss them just a little bit in order to give you a sense of the complexity of privacy law in Canada. So we have a whole variety of different legislation applicable in different jurisdictions, applicable to different types of organizations, which has resulted in a bit of what people refer to as a patchwork. While there has been many calls for legislative reform to streamline and clarify privacy legislation, which I think Jade might discuss in more detail later on as well, I think it's actually this complexity that makes practicing privacy law really interesting. And before I passed over to him, I actually wanted to talk a little bit about what practicing privacy law actually looks like, at least from the perspective of a relatively junior associate that has a general practice. So I would say approximately like 20 to 25% of the work that I do is privacy related. And of that privacy work, I can kind of divide it into full privacy mandates, partial privacy mandates, and kind of out of tangential privacy mandates, I would say. In terms of full privacy mandates, I use this term to refer to files that have at their absolute core privacy issues. And I'd say the most common, definitely, type of full privacy mandate is drafting and reviewing privacy notices. So we're contacted by organizations quite frequently who request that we take a look at their privacy notice that they often post on their website to people accessing their website or when they come into stores. And they asked us to ensure that this meets any kind of applicable privacy legislation and reflects kind of best privacy practices. So a good chunk of my time is spent looking at these different privacy notices, determining which privacy legislation is applicable, which is part of the fun complexity of privacy law, and then making sure that it reflects the actual nature of what they're doing and how they're handling personal information. The second kind of full privacy mandate that we often work on are standalone privacy questions. And this is probably my favorite type of privacy work to do. Essentially, organizations will reach out to us with a specific privacy question. Often it will be about whether their practices for obtaining an individual's consent to the collection of information is sufficient, or whether they're allowed to use personal information in a particular way, such as for email marketing. And it's a really great way to think about how the law applies to individual situations. And it also in doing so, makes you realize what some of the gaps in that legislation might be. One of the most interesting recent privacy mandates that we had was actually reviewing some proposed privacy legislation and making suggestions as to how we think this legislation could be improved, which is a really neat way of a very hands-on way of making a difference or impacting privacy legislation. So in terms of like these kind of more partial privacy mandates, we do a lot of privacy due diligence. So essentially other lawyers will contact us in the course of some kind of like merger and acquisition and ask to see whether we can conduct some privacy due diligence. Essentially that looks like us reviewing an organization's privacy practices, whether their privacy practices comply with like applicable legislation, and whether there would be any kind of risks associated with one company buying that company out. Often this actually has to do with data security as well. One of the big risks is whether a company has been subject to a data breach or whether their privacy practices make them vulnerable to a privacy breach. Another kind of partial kind of privacy mandate we get is reviewing specific provisions and agreements to make sure that there are sufficient cybersecurity mechanisms in specific contracts to ensure that the companies aren't putting themselves at unnecessary risk. And then in terms of tangential privacy mandates, often I use this like term to refer to files that don't actually raise any kind of privacy issues, but there's some form of nexus between privacy law and whatever that file might be. Often this is in the realm of IT. So privacy issues and cybersecurity issues can become very central in tech deals or tech agreements, where there's large amounts of personal information being transferred between companies, which results in potential significant risks. So we review those kind of agreements for privacy concerns. Another kind of tangential privacy kind of mandate that we get is reviewing terms of service. So terms of service often govern the use of websites by individuals, and this works really closely in conjunction with the rights and obligations of the company in regards to privacy concerns. So we kind of work with organizations to make sure that these reflect one another, that they work together. And it's really interesting. I mean, it's one of my favorite things is doing these kind of privacy notices, terms of service, answering privacy questions. It's primarily for a non-legal audience, and it's a really great opportunity to make legal concepts accessible to other people, which is one of the things that I find really, really rewarding and interesting. So with that, I am going to hand the reins over to Jade.
Thanks, Kelsey. So I'm going to pick up where Kelsey left off and bring it about 8 years forward in time, which is, I was called to the bar a little more than 8 years ago, and talk about what it looks like to actually practice privacy and technology law, as a senior associate. And these phrases have a lot of different meanings. There are people who do technology law who really focus on technology startups by doing their incorporation, shareholders agreements, financings, working with employment counsel and IP counsel to get them what they need there. There are technology lawyers who are really mergers and acquisitions lawyers who are just focused on the tech sector. And I don't do any of those things. My focus on the technology side is really a commercial lawyer. So Kelsey mentioned some of the technology projects we do, where what we're really doing is the buying and selling of IT services. And actually, I'm going to pause right there. I appreciate those of you who have your videos running, because I can tell if I'm being boring or not. I don't like Zoom for that reason, because I like to actually have a physical audience so I can gauge who's boring or who's bored and know when to shift gears. But one thing I can't do on Zoom is I can't tell when you're looking at your cell phone, because that's usually the best way to tell if somebody's bored. So if you could just go like that when I'm being boring, that would be great. So to jump into what these technology agreements really look like, we might be working for a company that does, is in the banking sector, for example, or transportation, and they need to buy a big software as a service product to run a big part of their business. It's usually, once you engage external counsel, it's often a critical part of their business. And so they need to run a big procurement process where they look out for which vendors are out there that offer a product that meets their needs. And then they get into a big contracting phase where they're hiring 1 to 2 parties typically to, one is the actual vendor of the software to provide that software to them. And then the other can be the vendor sometimes, but isn't always. And it's often a third-party integrator because they need to integrate that new product with all their existing systems. And these things can be millions of dollars. The biggest one I've ever done is a $600 million outsourcing over 5 years. So these contracts get really complicated in terms of making sure that your client is getting what they are actually think they're getting, allocating risk. And Kelsey touched on one of the most important risk allocation exercises we do in these contracts, which is negotiating the privacy and cybersecurity provisions. And it's why I say that there are not bright lines between any practice area. As a commercial technology lawyer, you're going to focus a lot of your time on getting the right data breach provisions into an agreement, on getting the right privacy compliance provisions into an agreement, and almost inevitably at the end of the day, fighting over the allocation of risk if there's a data breach. And these things get really complicated, especially in big scenarios where vendors, they can only take on so much risk because they're holding millions of records of personal information across multiple clients. And if they have a data breach that exposes them all and they're on the hook for all of them, right up to the lost profits of their customers arising from the loss of goodwill from a data breach, they'll just go under. There's no way a single vendor can actually accept that much liability in most cases, save for the Microsofts and Googles of the world. And so we spend a lot of time negotiating that. That all works into a privacy practice where sometimes Kelsey and I are brought on to deals to negotiate those specific parts. So the deal itself may not have a heavy technology bent, but there is an exchange of personal information. So we get involved doing the negotiations of those provisions. And that's when that line kind of blurs between commercial and privacy, but there's a lot of other things that a privacy lawyer might do. There are privacy-focused litigators, and honestly, in my opinion, it's one of the most interesting areas, even though I don't do it, where they're litigating these big data breaches that you're hearing about and unfortunately getting notice of in your email inbox when it's your data that's affected. The big ones lead to class action lawsuits, and it's a big ordeal to defend them. And increasingly, getting into the hot topics, we're seeing class action lawsuits that aren't about data breaches anymore. They're about over-collection or misuse or, intentional but possibly tortious disclosure of personal information. So I'm talking about the companies that are in the news for, being suspected of collecting personal information and then using it for ways that they didn't really clearly disclose to the individuals at the time of collection. Or are collecting more data through, a smartphone app or a website than the customer realizes they're collecting. I mean, it's usually true that when you explain to a customer or an individual all the personal information that's collected about them just through ordinary use of a smartphone application, it can be a bit surprising. And so that's now turning into, it's materializing as class action litigation. The other big thing that we work on, as Kelsey mentioned, is data breaches. And I get asked a lot, like, on a data breach, like, what do we need a lawyer for, right? Like, isn't that mostly a technical issue? And while, it's a technical problem, it's legal risk. So lawyers come in really to deal with the legal risk and with the regulatory requirements. The legal risk is around class actions, like I mentioned. And it's also around regulators investigating. So privacy commissioners, you'll see every time a big data breach makes the news, the federal privacy commissioner and often privacy or provincial privacy commissioners will say, we're announcing an investigation into blank company. And so we need to work with those regulators to try and explain what happened. But more urgently, we need to get a privilege strategy in place. So when a data breach happens, everything you're doing is anticipating the fact that your client is going to get sued. So you want to get your litigation team in there right away to make sure that, to the extent you can, all the communications that happen about the breach are protected by privilege. And most importantly, the forensic audit that's done by a forensic auditing team is done at the direction of the lawyers for the purposes of protecting privilege over that investigation. We also help with mandatory breach notification, which Kelsey mentioned, and it's a disparity right now between the Alberta legislation and the BC legislation, where Alberta has general breach notification obligations. If you're a company in Alberta and you control personal information and you have a data breach, if there's a real risk of significant harm to the individuals, you need to notify them. You also need to report to the Privacy Commissioner. If you're subject to the federal regime, PIPEDA, at least it's still called PIPEDA today, but probably won't be by the end of the week, there is a similar notification obligation where you've got to notify individuals, and that's why that came in 2018. It's why you've seen an uptick in notices about data breaches. They were happening before 2018. You're just learning about them now. But as Kelsey talked about, that confusing jurisdictional analysis, that's always a problem where, we have clients in BC, they don't necessarily have a legal obligation to notify. They might have one client or one customer who is in Alberta or in Ontario. And so they've got to notify that one customer, but not all their thousands of customers in BC. It becomes a sticky situation where you pretty much notify in BC just because it's, the cat's out of the bag. But you're also weighing the risks of not notifying voluntarily despite not having a legal obligation because of those class action risks and because of reputational risks where companies, really do want to be seen to be doing the right thing. And so they'll often notify. Working on these data breaches can be one of the most exciting things to work on. And similarly, one of the most awful things to work on. I spent a good chunk of my weekend, unfortunately, working on a couple of data breaches. It's basically whenever baby was napping or sleeping, I was on calls or helping draft communications or, advising on regulatory obligations on notification and reporting. They just happen very quickly. I'd say you never know when they're going to happen, but you do know when they're going to happen. It's Friday night, particularly before a long weekend. That's, for some reason, hackers' favorite hunting time. Or for some reason when people find out about it, or maybe it's just when they decide they need to bring lawyers in. But I had like 4 long weekends in a row where, found out about the data breach on the Thursday or Friday. We don't have prescribed notification timelines, but in the European Union, you need to notify within 72 hours of determining there's been a breach. So organizations really need to move quickly or risk substantial penalties. And in Canada, as a result, we also move quickly because we are, the legislation's vague, but it does say you need to do it as soon as feasible. So those are some of the hot topics. And then I'll spend 5 more minutes talking about what I describe as the second wave of privacy legislation, where I think this is most relevant to this group, because if you're looking to get a practice in privacy and cybersecurity law in Canada, it is really the right time to be getting into it. I built my expertise in this area when Canada's anti-spam legislation started to roll out in 2013, because it was a new law and there was no lawyers who knew the law, right? It had been, it was new. There was no real history behind it. Anti-spam wasn't even something that was regulated. And so I just read the law, read every piece of information that came out about it, blogged about it, helped my firm with its own compliance processes, got clients to give me their work, figured out how to do it, and then just knew the law cold. And it's quite similar to privacy law. So when I made my foray into privacy law, it helped me understand that. Now I really recommend to young lawyers or junior lawyers that if you want to build this practice, find these new areas of law where there just really are no substantive experts and build your expertise, get the work, figure out the right way to do it. So in terms of law reform, I'm kind of sitting here like hitting refresh, waiting for the federal government to release the Consumer Privacy Protection Act, which we learned on Thursday is the new privacy legislation that will replace PIPEDA, we think. Earlier this year, a new federal law was supposedly imminent and then got backburnered for obvious reasons, and now is apparently just about to be published. And so we're going to be, right before this call, I had an internal call with my team about how we're going to get out in front of this law. And it's something that any firm that's practicing privacy law is going to be aware of and getting in front of it, because inevitably all kinds of work comes out of changes to law like this, where you're helping your clients get compliant. You may have clients who want help with submitting advocacy documents to Parliament on how they want to see this law change before it gets to the final draft, before it gets royal assent. You may have to help clients with changing their privacy policies, with changing how they do consent, with renegotiating agreements with their vendors so you can get in the necessary privacy provisions. For example, if breach notification obligations change and we get like a 72-hour timeline, you need to have those in your agreement so your vendors notify you so you can comply with the law. And then there's all kinds of other compliance exercises that need to happen. And I say the second wave of privacy law because the CPPA, or I'm calling it SIPA, and that's what we're all going to call it now, I've decided, or SIPA. So when SIPA comes in, there's also at least 4 other reform efforts happening in provinces right now. Ontario just ran a consultation on whether or not it should adopt its own legislation. Their privacy commissioner endorsed that approach, cynically on my part, because if there's a Ontario law that expands her mandate, whereas I think it's quite bad for Canada to have a patchwork of privacy legislation when we ought to have a single statute. The privacy needs of Canadians, in my view, don't vary from province to province, and I've lived in Nova Scotia, Saskatchewan, and BC. I didn't really feel like my privacy needs changed from province to province, but legislators seem to think so. So we've got Ontario considering their new laws. We've got Quebec, which has published a first reading of its new laws and really kind of got everybody up in arms because frankly it's not well thought out. And then we've got BC, which had a special committee to consider changes to its privacy law. The first time I ever appeared before a parliamentary committee was that committee. They were very nice, but I don't know that they appreciate the work involved in drafting comprehensive privacy legislation. And then Alberta just released some new health privacy legislation, and hear rumblings that Alberta might be going to do more reform as well. So, getting back to my point, I think it would make imminent sense if we had consistent privacy legislation across Canada. We don't, but that creates a lot of opportunities for lawyers to sort out the complexity for our clients. Sean, I think I see we've got 25 minutes, so I'll wrap up there, but we could talk for hours about any particular topic. I'm happy to talk about the practical side of it if this team or this group is interested in how do I build a practice in privacy and technology law, or if you are starting to get into it and you have some questions about how a certain law applies and you're having a hard time finding an obvious answer from a privacy commissioner's website, and you want to get sort of the benefit of the years that we've been working on this and all the issues we've been dealing with. I'm happy to talk about substantive law too.
That's fantastic. Thank you so much, guys. I have a couple of questions whilst people drop their questions in the question box. So I will kick off with a couple of questions, but if you do have a question, please do drop it in the question box and then we can call on you in turn to ask your questions. Kelsey, how did you go from summer student in litigation to now working in privacy and technology law and building, your own corporate commercial practice area?
That's a great question. As Siobhan mentioned, I started out as a summer student based in litigation. And I think one of the reasons I ended up in litigation is that law school really prepares you for like a litigation or a litigation-based practice as opposed to a solicitor-based practice. So it's really hard to get a sense of what practicing business law looks like during law school. And I quickly found that I did not have the stomach for a more adversarial type practice, and that I was more inclined to a more kind of collaborative type practice, which is generally what business law looks like. You work closely with clients, and even on deals, you're working collaboratively with opposing counsel towards a common goal. And I think that's the best distinction between solicitor and litigator-based practices. Now, in terms of getting into the kind of privacy IT area, I had the opportunity to work with Jade as well as other associates in the IT and privacy group when I was articling, and found that I liked the technicality of IT agreements, which can get very, very long and very, very technical. I think one of the main things I enjoy about, privacy work is that a lot of it is done for, as I mentioned before, non-lawyers. And so it is an opportunity to make law accessible. And yeah, I would say that that's kind of what drew me towards that type of practice. Obviously enjoying it so far, so.
Yeah, that's fantastic. And you were called relatively recently, right? That's
right. I'm a second year call. So I was called in 2018, yes.
Exciting.
Early days. I'm sure I'm behind, if not, only slightly ahead of many people on the call.
Oh, it's fantastic. No, everyone's getting great advice here, and you're getting it from two very different stages in people's careers. Kelsey is, a 2-year call associate. Jade is going to be a partner in January. So you're getting to see what the practice is like from two different points in their careers. And you can already tell from what they've been telling you about the work they're doing that you do get involved in different aspects of it as your experience grows, and you have that opportunity to build up that sort of historical knowledge of all the different contracts that you're dealing with and all the different legislation. And for you guys, you're actually doing hands-on legislation writing and reviewing all of the time. And how does that work, Jade, in terms of working across different provinces? Because there are many practice areas where you're very much bound to working in just one particular province because of the jurisdictional issues. But it sounds like for you guys, especially around privacy law, you've got a much more national approach to how you're able to work. Is that fair?
Yeah, it's a very fair point. So we're a national firm in the sense that we have offices in Quebec, Ontario, Alberta, and BC. We also have lawyers, including myself, who are called in other provinces. But because right now we have offices effectively in every jurisdiction that has its own privacy legislation, we have experts on the ground in each of those offices that we can turn to for specific issues. To be honest, once you're a common law called lawyer, understanding the distinction between BC and Alberta's privacy legislation it's a breeze. You could do a red line against them. They're not that different. And then PIPEDA, the federal legislation is, I think no matter who you are as a lawyer, if you read it, you would think this is really weird. This doesn't look like a statute that I've seen before. It's got this model code appended to it with these 10 privacy principles. And it's, a principle, they call it, principle-based legislation, which in theory should make it very flexible and allow the building out of new concepts as technology and practices evolve and the need for the law to grow around them grows. I don't want to compare it to a constitution, but that was, I think, some of the vibe behind it is that you want to write a document that's going to exist for decades, even though the world changes. So we advise on those. I have no problem advising on those, and where I need help in Alberta, get help in Alberta. Quebec is really the weird one. Coming at it from somebody who went to a common law school only. Fortunately, I have Kelsey who went to McGill, and so she's very helpful in helping me understand Quebec law. And then we also have a team of privacy lawyers in Quebec who can give us the more specific advice when we get into those issues. When it comes to things like advocacy, like pushing governments to try and adopt more uniform and easy to understand and easier to comply with privacy legislation, I find our national practice actually makes it really helps us see things sort of 360 degrees, because we can get everybody in a room, and we've got experts across the country on various issues. And we also have a lot of experience with working with GDPR, the European Union's privacy legislation, which, gets called the gold standard of privacy law. And increasingly the California Consumer Privacy Act, which is quite a different statute, but also comes at it from a different angle, and so gives you another perspective on how privacy law can be. And so when it comes to those advocacy projects, I think we can advocate for, what really works based on what we see in other jurisdictions. So yeah, it's the national team is really important on that front. I think privacy law is at a level of complexity now where if one lawyer holds themselves out as being the expert across all Canadian jurisdictions, be skeptical. You really do need to have teams.
Fantastic. Anna, MJ, do you want to ask, or Anne, MJ, sorry, do you want to ask your question? You can unmute yourself.
I can just read it and field it if you'd like to. If Anna, MJ is shy or has left.
How critical is the CIPPC certification in building a career in privacy in Canada? And for those people who don't know what that certification is, Jade, can you give a little bit of a rundown of what it took for you to get that certification, please?
That's a good point. Thanks. So the sort of leading organization in privacy law is the International Association of Privacy Professionals. It's broader than just lawyers. And increasingly, there are people who may have some degree of legal training or may not, who are acting as privacy officers and helping with compliance within organizations, and who are also acting as consultants. And they all fall in this organization. This organization offers a series of different certifications. The one that's most relevant to lawyers is the Certified Information Privacy Professional. I always want to say Information Protection Professional, but Certified Information Privacy Professional. I hope I'm not getting it wrong now, because I have it. It's a Canadian, they have certifications for Canada, the United States, Europe, and I think a few other jurisdictions. And the gist of it to get one is you just need to pass an exam. And then once you have it, there's a CLE component to maintain it. It kind of came out of nowhere. I only heard about it a few years ago. And now I'm seeing all kinds of people with it in their signatures, including staff at the offices of various privacy commissioners. I'm also seeing a lot of job postings from organizations that say, we expect you to have this certification or be able to get it within 6 months of being hired if you want this job. So to answer the question, is it critical to get this certification? No, I don't think so yet. But if you really want to work in privacy law, the expectation is you're going to get it in the near future. Ideally, you want to get it in an organization who's going to pay for you to get it, because you need to be an IAPP member and you need to pay, I think, $500 US to write the exam. And you need to pass your first try, or you need to pay a few more $100, I think, to rewrite. So, I mean, you're looking at nearly $1,000 Canadian up front, and that includes if you don't take a course and you can, or pay for their materials, which I did not do. I wrote the exam and I passed. I don't remember by how much. I didn't knock it out of the park, but I also didn't try to knock it out of the park because I was kind of willing to go in and fail and go back and see because the firm was paying for it. But my advice on studying for it, I can provide in a separate note, but you really need to know the federal legislation, PIPEDA, and the Privacy Act. You also need to know anti-spam law. You need to know a bit about parliamentary procedure and what, it means that the Federal Privacy Commissioner is an officer of Parliament. You need to know a couple of leading decisions, but most importantly, you need to read their existing exams, their practice exams, because the questions come up again. So that's what it takes to get it. Now, is it a good use of your time to study really hard for it, to learn privacy law? I'm not so sure. Honestly, a lot of the questions did not come off as the analytical type questions that a lawyer would need to respond to. They came off as more like an undergraduate exam, where it's asking you to sort of answer questions that you would know the answer to based on just memorization. So if you've gone to law school, I mean, a question might be, is the license plate on a motor vehicle personal information of the driver of that motor vehicle? And that's a kind of gray area privacy law question that you would expect, to have to give a complicated answer where you can show how you can think it might be personal information, how you think it might not be. The answer is it's not, by the way, but it's the kind of question you'd expect to see on something that's testing analytical skill. Whereas the kind of questions you see on that exam are like, what kind of privacy law does Canada have? A sectoral approach, a comprehensive approach, or something like that? And the answer was a sectoral approach, because we have government legislation, we have private sector legislation, and we have health privacy legislation in certain jurisdictions, which to me is meaningless. Like, who cares that it's sectoral? It doesn't help you know what applies in what situation, because, for example, if you're working for a healthcare provider, it's not necessarily healthcare legislation that applies to what they're doing. If it's their employees, it's either nothing or the private sector legislation. If they're a government healthcare provider, then it's government legislation. It's not necessarily the healthcare legislation. So all my roundabout way of saying is, you want to look at getting a SIP certification at some point, but if you really want to learn privacy law, it's not the best way to go about it.
Hopefully that answers your question, Anne. But I guess if you're sitting there, looking for a job and you have time on your hands, then now might be a good time to do it. If you have that extra time, certainly wouldn't hurt. Nicole S., do you want to ask your question?
I was just curious, how would someone get into privacy and IT if you don't have the experience? Like, if that's not the area that you articled in, or you didn't take any courses in law school?
Kelsey, why don't you have a go at this first, and then Jade can back you up with his thoughts. But I mean, you came from, a litigation kind of background and then moved across into it. So how did you make that transition? You're muted though.
That was bound to happen at some point. As Siobhan mentioned, I don't have a background in technology. I didn't take any, privacy or IT courses at law school. I kind of only encountered it for the first time during my articles. I think it depends on, your particular setup. If you're already at a firm, if you're looking for a position at a firm, if you're already at a firm, approaching lawyers directly and just expressing interest is always the best way to go about it. I think particularly as a fairly junior lawyer, you're never going to be expected to have a wealth of experience when you approach a lawyer for the first time saying, I have an interest in X and Y. If you're kind of in the process of looking for a position and are sure or have a sense that you might be interested in IT or privacy work, this might be a situation where it would make sense to get some form of professional certification, if only to demonstrate that this is an area of law that you're particularly interested in. I would say that's probably about it, but Jade might have some better advice.
I'll build on that. I mean, to me, the most important thing is to find somebody who's already doing what you want to do and get them to teach you how to do it. The most valuable experiences I've had are working for more senior lawyers at McCarthy's, who have given, the benefit of their experience in terms of telling you the things that you can't read in a book, the things that don't get published because they're things that go on internally with a client that are, confidential and that they'll never publish, the things that go on between conversations with regulators that they don't publish, and then the things that, happened years and years ago and nobody remembers and maybe aren't published anywhere. And then also helping you, most importantly, become good at analysis and spotting issues and knowing how to deal with those issues. And then maybe more importantly, communicating those to the client in ways that the client is going to actually understand and be able to put into action. It's what Kelsey was going back to, is often you're communicating legal information to people who don't necessarily have legal training. And so you need to translate the academic world of law into real practical things that a person can do. And you only learn how to do that by doing it and being corrected, frankly, when you're, go offside and not doing something well. The ways I think to get that kind of person is obviously do everything you can to show a genuine interest, get whatever kind of experience you can. There may be pro bono organizations out there that you can go work for to get that kind of experience. And then find that person within your firm or within a firm that you're applying to who's doing it, and do anything you can. Honestly, a good attitude goes a really long way. We have in privacy, one thing I'll tell you that you don't get in other areas of law is there's a lot of non-billable work. You need to stay up on the law, and you need to show other people that you're staying up on the law. So that means a lot of reading and a lot of blog posting kind of things. And so if I can get help from a junior who on those types of efforts, the fruits of that effort when we get the billable work is going to go to them, because it's shown they've taken the time to actually learn this stuff, and they're going to put out a better work product. But it's also just fair that if they put in the work, they should get the results. And then I'll make maybe a controversial statement to close this question off, which is that, this is a really great and interesting and growing area of the law, but you should always ask yourself, why is it this important to me? To be honest, I could have been a corporate M&A lawyer or a real estate lawyer, and I think I would have really enjoyed it, as long as I had the most important things, which are, really good lawyers to work with, people who are not just smart, but who are kind and who are good to work with, clients that are really reasonable and value your efforts, and expertise. It's far more gratifying to be an expert in a topic, I think, than to be an amateur in an interesting topic. More gratifying to be an expert in a boring topic than it is to be an amateur in an interesting topic. You get to that stage in your career where a client phones you for something that might take another lawyer hours or days to research, and you know the answer off the top of your head. It's a much better feeling, even if that's about easements or some obscure topic in real estate law. So this is interesting. This is a great area of law, but don't close your mind to something if you've got those other ingredients available to you.
Good points. Very good points. And you mentioned there, because I'm going to expand on that slightly, is reaching out to people around you who have more experience in the area. And you specifically talked about how there are other lawyers within McCarthy Tetrault nationally and also regionally. But what if you don't have those people at your firm? What if this is an area that currently your firm doesn't do? How is the community at large have you experienced with people approaching them from other firms to like pick their brains and maybe be quote unquote a mentor for somebody?
You probably have to ask 10 times to get one response, but you will get responses. My experience has been that the best way to get that kind of mentorship externally is to get involved in an organization like your local CBA chapter or IAPP. And again, do non-billable work for those lawyers who know this stuff. They don't need to be in your firm. If you're helping them organize meetings, if you're helping them put together submissions that the CBA group is putting forward, and then you say, hey, can I have coffee with you? You're going to get you're a lot more likely to get a yes from somebody you've, done a quid pro quo for, sorry to use Latin, than just cold emailing lawyers on LinkedIn. Like, get into those organizations. The other angle you can come at it from is if you think there might be somebody in your firm who's interested in it and who is just senior, talk to them. There are different practices that dovetail with privacy. Technology, commercial work is a big one, and employment law is a big one. So most firms have somebody who does employment law. You may want to talk to them about the employee privacy issues that come up and start to become the expert in that. and find that as your wedge issue. And then you just become known in your firm. If nobody does it in your firm, then maybe questions start to come to you. It's how I get a huge amount of my work at McCarthy's is just I yell very loudly that I do privacy work, and it comes to me. And the last thing is there's always lateraling. You know, it's an option that is on the table. I'm at my third firm, so don't ever think of lateraling as a career killer. It's Kelsey, please don't listen to this, but you know, you can find a firm that's the right fit for you if the firm you're at's not, especially if you've got a couple years of experience. And Siobhan, I apologize. I do have, I hate this phrase, a hard stop.
No
I don't know
problem.
if Kelsey does, but Kelsey might be willing to stay around and answer questions.
No, I truly appreciate it. And I know we didn't get to a lot of questions. There are quite a few still in there. But we are going to let you all go because it is the start of a new week. And I know the new legislation is coming out and you're just itching to go away and read it, Kelsey, and then come back. And so make sure you are following Kelsey and Jade on LinkedIn because they do share the blog articles that they write for the McCarthy Tetrault blog and also for other publications they do. And you never know, maybe they might need some help. So it's worth connecting with them on LinkedIn because maybe they would like you to read the new legislation when it gets released later today. And maybe you can help them do some of that reading and analysis of what that legislation shows. But Jade, Kelsey, thank you so much for coming today and sharing with us a bit more about what privacy and technology law looks like for the two of you. Jade, congratulations again on making partner. That's a very exciting way to end the year. And we look forward to seeing you again, hopefully in the future. And everyone else, thank you so much for joining us. Thank you for your questions. We do have another virtual mentor office hour session this Thursday, 5 p.m. Pacific, 8 p.m. Eastern, and we're going to be looking at health law and also about why it's important for you as legal practitioners to look after your own health and wellness so that you are fit to practice for your clients and for life in general. So please do join us for that one. Guys, thank you again so much. Have a great rest of your week and we'll be in touch soon.
Thanks, everybody.